No federal guarantee. You're on your own when you go into crypto, correct?
Yes.
Yes, it's a field that's rife with abuse and fraud.
Do you ever issue a rule where everyone says this is just splendid and we're all happy?
No,
Does commission know yet what it's going to do? Are you going to ask for an en banc hearing or appeal, or have you decided yet?
it's commission has not yet.
Would you tell me if they had?
Yes.
Of course, of course. The CEO of Alibaba got crossways with President Xi, and unsurprisingly, President Xi won. I know I need to get a life, but I sat down and read Judge Englehart's opinion.
And most do not realize that there is no insurance involved in this, no federal guarantee. You're on your own when you go into crypto, correct?
Yes.
Yes, it's a field that's rife with abuse and fraud, and at least in the those tokens that are crypto securities are not properly giving people the disclosure that you'd get for any other offering.
You've been quoted, Mr. Gensler, as saying it is rife with fraud, scams, and abuse. I think you just about repeated that.
Yes, and some of the leaders 2 years ago in this whole field are either in jail, about to go to jail, or awaiting extradition. I mean, tens of billions of dollars have been put at risk.
Despite the House bill, Chairman Behnam, we have those who worry that the CFTC is biting off a hell of a lot more than it can chew when it says they want to play in crypto and regulate the industry, at least some aspects of it. What in the world makes you think that you can get into this fast-moving, capacious world and be effective as a regulator?
Senator, using the word play, I think I would sort of disagree with that respectfully. This is our responsibility. This is my responsibility as chair to make observations about commodity markets and to relay what I observe to all of you. And currently, there is a gap in regulation over non-security commodity tokens. Our enforcement record at the CFTC, I think, demonstrates our success and our expertise. Over the past 10 years, we brought 135 crypto cases. We've brought in billions of dollars. And we've successfully policed a market where we don't have direct authority or jurisdiction, which ultimately leads to all of this fraud and rampant abuse in markets, and ultimately public mistrust, lack of confidence, and loss of funds. So we are one of two market regulators in the U.S. financial system. We are adequately equipped to oversee the markets that we traditionally oversee.
Yep. What makes you think you're adequately equipped to deal with this market?
Finishing that statement, we are adequately equipped to oversee the markets we are mandated to oversee. But if we were to be given authority over crypto markets, I would certainly expect there to be an increase in a budget.
Let me ask you, Chairman Gensler, do you have, having lived the life of chairman of the CFTC, do you think that agency is capable of handling the responsibilities we're talking about?
I'm going to be conditional. I think it depends on what they're given. I think that the Congress's wisdom was to have an agency to oversee disclosure-based markets where issuers are asking the public to buy and sell their securities and are investing in those. And most of the crypto market is that. There's 15 to 20,000 of these tokens, and without prejudging any one of them, most investors expecting to benefit from the efforts of others. That disclosure-based regime has not been set up at the CFTC. The CFTC I love. It's a great agency, but it was set up to do the derivatives. There's not disclosure, for instance, mandated, required, nor has Congress suggested on corn, wheat, oil, or interest rates. So it's this disclosure-based regime that we have at the SEC, and I would say that largely the crypto field has been thumbing its nose at it and been non-compliant.
Ant Group, a subsidiary of Alibaba, announced an IPO. And everybody was all a titter, going to invest in this extraordinary IPO because Alibaba is such a successful company. And the CEO of Alibaba got crossways with President Xi. And unsurprisingly, President Xi won. And he canceled the IPO, he meaning President Xi, for Ant Group, the subsidiary of Alibaba. And of course, after the announcement of the cancellation was made, Alibaba stock dropped about 8%. You remember that? I did some checking, and 2 days before the announcement that the IPO was canceled, a bunch of insiders at Alibaba dumped about $150 million worth of Alibaba stock, therefore avoiding an 8% loss, which other investors who didn't know about the IPO cancellation had to swallow. Insider trading. And I said, how can this be? Well, our law provides, I'm not blaming it on you, this is Congress's fault. Our law says that if you are the CEO of an American company and you sell your stock, you've got to report it to the SEC within 2 days of the sale, and you've got to report it electronically. You can't use snail mail. And you post it there in front of God and country on your internet, on your website. But a foreign executive doesn't have to do this. The foreign executive, he has weeks to inform you that he's executed an insider trail, and he can then send it to you by snail mail. And it's not even posted on the website. So Senator Van Hollen and I have a bill to basically say the foreign investors and the foreign executives have to follow the same rules as the American executives. I mean, insider trading is insider trading. Will you support that? We talked to my Democratic colleagues.
I think that you're addressing something, Senator Van Hollen, and you are addressing a gap in our current regime. We have about 1,000 of these foreign private issuers, and you're right that they don't have to currently file within 2 days electronically their trades, and I think that would help close a gap. There's another gap that's actually a 25-year-old rule, and I've asked staff to look at, called Regulation Fair Disclosure, or FD, when it was under Chair Levitt some years ago that he put it in place. A simple concept. If you share material non-public information to analysts or Wall Street or to the press, you've got to put it out to everybody. And it's helped protect the public. Fair disclosure. But guess what? There's an exemption there for foreign private issuers as well. So I've asked staff to take a close look. We'd have to go through notice and comment rulemaking to change that.
Good idea. Well, we're going to try to move our bill by UC, unanimous consent. I can't imagine anybody will object, but I've seen it happen before. So any help you can give us. I wanted to, last weekend, I know I need to get a life, but I sat down and read Judge Englehart's opinion in the, I forget the name of the case, National Association of Private Funds Managers v. SEC. It's the private funds rule case. And I thought the opinion was, regardless of what you think about the result, I thought it was well-reasoned, well-written, far-reaching. And I wanted to get your thought, and I know the Fifth Circuit en banc can change it, and the Supreme Court might review it, but I wanted to get your thoughts about the consequences of the holding in that case, holdings, on your other rulemaking procedures.
I'm glad that you read the case, and of course it's in the Fifth Circuit, it's in New Orleans. So. Yeah. But we're still reviewing and thinking about our next steps. But I think that what it said, and Senator Hagerty and I were talking about it, is this new provision 14 years ago in Dodd-Frank, Section 913 of that.
Which is part of the Advisors Act.
Part of the Advisors Act. You might remember it's 211H of the Advisors Act.
Yeah.
that talks about new authorities about investors. The court read that to be just about retail investors. And so we're looking at that, but if you're asking me, that means that narrows that authority. Of course, we do everything within the law and how courts interpret it, but we're just still thinking about the next steps. But it would narrow that authority to, I think as they read it, I'm using a colloquial word, retail investors.
One of the things, Mr. Chairman, that got my attention, and you can debate whether it's part of the holding or not, but the court seemed to seize on the fact that in terms of your fraud rule, based on the SEC's experience, out of the thousands and thousands of these private funds, you've only found 0.5%, not 5%, 0.5% instances of fraud, but yet the requirement to comply with the private funds rule was going to cause the private funds industry over $5 billion a year. Obviously, it was a cost-benefit analysis. That made sense to me. What do you think?
Well, with all respect to any court and so forth, we put certain things in a filing and we listed, I don't remember, a couple dozen examples. They're exemplars. We in our enforcement, and what we do in enforcement is we have cases when it comes to our attention and we pursue that fraud and then we either settle or we litigate. And so we were giving some of those examples. But again, we're still looking at that case. We're looking at the opinion, trying to determine next steps. But I think that in any area in the law, if we have examples of fraud, that's to help protect the public. And it's not whether there's tens of thousands of them, but what in that case, a couple dozen real cases that we were able to point to.
But the question was being raised, and I'm going to shut it down, Chris. Cost benefit, okay? And the court was saying that there are only 0.5%, half of 1% instances of fraud based on SEC experience. But the SEC issued a rule that was going to cost everybody $5 billion a year, and does that make sense? And I think it was raising that issue.
Well, we address ourselves to cost benefit, I think, in a very serious way as to what problem we're trying to solve. In this case, what we were trying to solve is information for the limited partners investing in private funds, and behind those limited partners, of course, are pension funds, endowments, your state pension funds probably in your states. To have quarterly reports to them on the performance fees and arrangements with other investors. And this was not meant to be public information. It was just too private information to those. I think that would promote greater competition and efficiency in that market. But again, the court had a different view on this important Section 913.
Your proposed predictive data analytics rule, what effect, if any, do you think the Fifth Circuit opinion will have on that rule?
Again, I think you'd appreciate if I say that our staff is still reviewing the Fifth Circuit and will give advice to the 5-member commission under General Counsel Barbero's leadership. I've also want to note for you, you may not be aware, we got a robust comment file on the predictive data analytics rule. A lot of people for, a lot of people against, raising different issues about the scope of that rule. And I had already asked staff to consider whether we should either reopen or repropose that rule given the breadth. And we even did, and I say this, Chair Behnam might not be aware, we did that on a safeguarding rule as well, and we had been talking a lot. I've asked staff, should we reopen or repropose that safeguarding rule as well? So while we're considering that on the predictive data analytics, we'll also get the best advice from our general counsel around the Fifth Circuit opinion.
Do you ever issue a rule where everyone says this is just splendid and we're all happy?
No,
You generally get comments.
I would say
both sides, do you?
to get my vote, I'm only one of five, but
understand.
I really strongly believe in our constitutional system. Do it by the law and how the courts interpret the law. And we present ourselves to the American public, and that's important to the trust in the system. But if the courts see it otherwise, we adjust.
Sure. What about the impact of the Fifth Circuit ruling on your outsourcing rules?
Again, I'm going to defer to getting the best advice from our Office of General Counsel, our Division of Investment Management, and sorting through that. And in any, not just this Fifth Circuit, any ruling by a court, sometimes not even related to the SEC, we take a look at it. Does it have an effect on something that we've already put out there, and do we adjust?
Yeah.
And I just think that's part of our great democracy.
So you just can't say yet. Would that be fair?
That would be correct on the outsourcing rule.
Okay. Well, the language that the Fifth Circuit used is also present in the Exchange Act of 34, isn't it?
If you're referencing Section 913
Or
of
the language
Dodd-Frank,
interpreted, yeah,
put the similar language in the Exchange Act, both in what's called 211H of the Investment Advisors Act and a compendium similar language in the Exchange Act.
Yeah, I misspoke. I should have said the language that the court interpreted is also appears in the Exchange Act of 34.
One of the provisions, the 211H.
Well, that language that the court interpreted in the Fifth Circuit also appears in sections 9J, 14E, and 15C, 2D of the Exchange Act of 34. So it could implicate your rulemaking authority under those provisions too, couldn't it?
Again, I'm going to look to General Counsel Barbero and her team, and of course the divisions of trading and markets and investment management for good advice, and all five of us will.
Okay. Does Commission know yet what it's going to do? Are you going to ask for an en banc hearing or appeal, or have you decided yet?
It's Commission has not yet.
Would you tell me if they had?
Yes.
Of course, of course. Thank you, Mr. Chairman. I enjoyed talking to you. Thank you, Mr. Chairman.